Good morning, everyone, and welcome to this month's ITCC Import Workshop. I'm Brian Walsh, and I'm the chair of the Import Workshop series, and very happy that you all could join us today under these unusual circumstances. I think we've been doing these seminars now since 1987, and this is the first time that we've been doing it via webinar only. But hopefully this works out and we can have a very productive session this morning. Our speaker is Larry Friedman, who I think pretty much all of you know already, but just to review, Larry was a law clerk at the United States Court of International Trade for Judge DiCarlo. He's the past president of the Customs and International Trade Bar Association and is on the faculty at the University of Illinois Chicago Law School, and I'm very happy to say he's been my partner for over 25 years. And he's going to be speaking today on the topic of tariff engineering, all-you-can-eat buffet or customs fraud. And we do have the ability, I should say, we do have the ability to see questions. So if you click on the chat box there and type in questions, Larry will see those as they come in and try to give a response. Okay, Larry.
All right. Thank you, Brian. Brian's going to leave the room now to maintain our social distancing. So thanks everybody for taking the time to do this. And for those of you who normally we would see locally, hopefully we will have the opportunity to see you all soon. The other thing about the chat box, feel free to, or if somebody could, just let us know how the audio sounds. I want to make sure that this is all going out. We think we've got this set up right. So if you're having any issues, hopefully we can resolve them, but let us know. So I've done this presentation before, so if you've seen it before, stick with me. There's new material from the midpoint on and some new examples, and there's a lot going on. So let's get, I'm gonna turn that off. All right. So tariff engineering. So the point of tariff engineering is to look at the structure of your product in a way that takes into consideration the ultimate tariff that you'll be paying on the product. These days, that may be more important than ever, given the numerous additional tariffs that are being applied to products. The reason you're looking at a Chinese restaurant menu is that there's an easy analogy, an easy way to remember this, and to the extent that you have the opportunity to explain it to your management and get involved in the development of products from a tariff and trade compliance standpoint, this is a good way to do it. So it also just works out well because I am well known for enjoying a good meal. So this particular menu features a couple of different kinds of mushu preparations of meats. So you can go through and see what you want to eat. I'm a big fan of mushu chicken, so if I'm looking at that on this menu, I'm going to see that it is $8.79 a quart, which, by the way, seems like too much for a single meal. I don't know why they don't sell it in a pint. But so I've got that as an opportunity. So basically, my tariff for buying mushu chicken is $8.79. But this menu is effectively your tariff schedule for food. If I look at the rest of the menu, I can identify an opportunity to do a little restaurant tariff engineering and see that mushu pork, same 5 pancakes, same preparation, different protein, is about $2 cheaper for $6.95. So my tariff is lower on mushu pork. So the question is whether that is an appropriate substitute to make And that's basically it. So we're sitting around the table. Is it okay with my wife? Is it okay with my kid? Are there other penalties or problems? You know, am I allergic to pork? Am I staying kosher that week? I don't, you know, if I don't have a problem, it all works for me. And that is exactly what we're talking about here, except we're doing it from a tariff standpoint for products that you're, for those of you who are brokers, that your clients are importing, for those of you who are in-house compliance people, for the products that you are contemplating bringing into the country. That's simple analogy. I think that works really well when explaining it to your colleagues who may or may not be that well versed in tariff classification and the impact of it. So what we'll do, so yeah, this is your engineering. So if you apply that to your product, you've successfully tariff engineered. So what we'll do here, as Brian mentioned, I teach at the law school, the UIC John Marshall Law School, and we'll go through some examples of cases and rulings on how this has been applied, and then we'll apply it to current events and to some examples you may see in the stores when you're back out going to stores. All right, so the first case we'll talk about is, this is kind of my favorite of these cases. It goes back to 1882, and the imported merchandise was sugar. The way the tariff worked is in the bottom box here, is depending on the Dutch standard color, the tariff went up or down. And basically, the lighter the sugar, the more refined it was, and the higher the duty. So the standards are assigned numbers, and up to the number 7, you can see was about 2 cents a pound plus 25%, and above 7, a higher number, was 2 cents per pound plus 25%. So there's a small deviation there. I shouldn't have rounded the first number, but it was worthwhile enough for somebody to want to try and change the classification of the product. So this is an image I was able to find. This is an actual set of Dutch standard sugar for use in classifying or grading sugar. So for some reason, whoever took the picture didn't bother to put them in numerical order, but you can see the lower number is a darker sugar. So number 9 there has more molasses and other material in it. It's the darkest. The number 16 there is lighter, and this has to do with the removal of materials and smaller crystal sizes. So what happened in the case was the collector, who today would be the import specialist or the port director, believed that the sugar had been intentionally colored to change its Dutch standard tariff classification, as opposed to having its natural color after refinement. And because the collector was suspicious about this, he, and I'm going to assume it was a he given the year, performed an actual chemical analysis to determine the size of the relative size of the crystals using this device here called a polariscope, and found that the sugar had actually been more highly refined and then essentially died back to its to a lower number color, and therefore subject to the presumably it was entered at the lower rate of duty. So the import specialist today, in today's parlance, rate advanced that to the higher duty and probably made accusations about the truthfulness of the import. So this went to the court, to the Supreme Court, when I say the court in this context, and the court made it clear, that Congress was the party that sets the test for tariff classification. And in this case, the Congress set a rule based on color. and that is what the customs collector needed to apply. So the tariff classification language was not dependent on size of crystal or even on level of refinement. It was based on color. And what the court said is that is that's the test to use, and that's the test that needs to be applied, despite the fact that the importer has adjusted the product itself in order to establish a lower rate of duty. So the key language here from this case is at the bottom here: so long as no deception is practiced, so long as the goods are truly invoiced and freely and honestly exposed to the officers of customs for examination, no fraud is committed and no penalty is incurred. Right. So the point here is, well, we want to unpack that a little bit. The issue here is clear that the goods have to be truly invoiced, right? You cannot make a false statement on an invoice or in modern days on the entry and expect to get through this process without problem. So first thing is the product has to be properly declared and then freely and honestly exposed to the officers. So in those days, there was a much higher likelihood of physical inspection. But again, the merchandise has to be made available to customs for examination if they so desire. So in other words, you're not sneaking things across the border or hiding material inside something else in order to avoid duty. None of that is appropriate. That will always get you into trouble. But at the same time, it is clear that you're allowed to make a product in such a way that you avoid higher rates of duties and establish the merchandise classifiable in a lower rate of duty. Okay, so moving on to 1912, and we have a few of these, but not as many as you may have seen before. This case is extremely important today. We're going to get at the end of this presentation to what's been going on with the Ford Transit Connect vehicle, which is the current poster child for tariff engineering. And this case is critical to that case. So this is a 1912 US Supreme Court case. Just like Merritt, the previous case, both of these cases stand today. They've not been reversed. They have not been revisited. So they are what we would call binding precedent on the Court of Appeals for the Federal Circuit and the Court of International Trade. So what happened in this case, which I think is properly pronounced Citroën. Someone who speaks French can put the phonetic pronunciation in the chat box for me. But what happened was a person, this is a passenger case, was traveling in France, found a necklace that he thought would be appreciated by his wife. Doesn't say what this person did for a living, but it seems like it might have been a customs broker or a lawyer, or somebody who had a good customs broker on the other side. So there's a necklace purchased in France, and it's 37 pearls. They were strung and they had a clasp on them. Prior to arrival in the United States, the purchaser, who's the importer, unstrung the pearls from the string and divided them into 5 lots by size. That was done so that the person could reassemble the pearls back in the same shape and design of the necklace. So when imported, there were 37 loose pearls in 5 separate lots. The classification debate was around in those days, paragraph 434, jewelry at 60%, or pearls in the natural state, not strung or set, 10%. Okay, so obviously the person at the time of importation asserted paragraph 436 and the 10% rate of duty. And as you can tell, because this is a Supreme Court case, customs disagreed. So that's what pearls look like. You probably all know that. So the Supreme Court decision states a couple of important facts to keep in mind. And again, what you need to keep in mind and take away from this is how you can explain this to management, to people who are doing product design, specification, and what you need to keep in mind so you're not crossing a line, which is what we're leading up to, and how to make sure you're doing this legally and appropriately. So the Supreme Court decision was, importantly, classification is ascertained by an examination of the article in the condition in which it's imported. Okay? Then the court went on and basically reiterated what it had said in Merritt versus Welsh, that you cannot get to a certain rate of duty by disguise or artifice. So disguise or artifice would be doing those things that the prior case said you can't do, right? So it has to be properly invoiced, and it has to be presented to customs in a way that it can be inspected and it is clear what the merchandise is, right? So no hiding the ball, but you can change the product so that in its condition as imported, when it's classified, you establish a favorable rate of duty. So, and then the decision is, when it is found that the article imported is in fact the article described in the tariff, then that tariff act is what is applied. An effort to make it appear otherwise is simply fraud on the revenue and cannot be permitted. So this is the line to be drawn. If you've crossed into disguise or artifice, not properly invoicing, not telling customs what the merchandise is, not answering questions appropriately, or in the worst case, not presenting it for inspection, you've crossed the line into fraud, and that, according to the Supreme Court, cannot be permitted. But that does not mean that the first two bullets here are not still binding, which is condition in which it's imported is what matters. And from the previous case, from the Merritt case, you apply the test from the tariff as it's written. Okay, so the holding here is that the merchandise was classified as pearls in their natural state, not strung or set. And that includes these pearls, which had been drilled, right? Obviously, because they were strung previously. So the court said not strung implies that they may be ready for stringing. Pearls are often drilled immediately after being removed from the shell. And 434, which is the jewelry provision, requires that the pearls be set or strung. So this is a little bit of a problematic choice here, right? Because the only choice was pearls in their natural state, which these manifestly are not, in that they've been drilled. On the other hand, they're also clearly not jewelry, right? So as between those two, there was no third option, which, drilled or some other treatment. So 436 makes sense in this case. Although the court had to do a little dancing around the fact that they were drilled. So this is obviously a big win for the importer. And the important thing to keep in mind is that at the time of importation, it was clear to everyone involved, clear to the importer, clear to customs, clear to the courts, that the intention was to restring those pearls into a necklace again. So this was a temporary condition when imported, and that's going to come back and be relevant to discussions for what's happening today. I am watching the chat box, so if anybody's got questions, don't hang on to them, but we will push on. So we're going to skip ahead to some customs rulings. And you'll see that customs has latched on to, I don't mean that in a negative way, but they apply the disguise or artifice test when they're looking at potential tariff engineering versus potential tariff fraud. And you can see how this is applied in the sort of rules that they have built around it. So there's this ruling from 1991 on feather dusters that were imported under 9603, but the feather dusters were never actually sold as feather dusters. In fact, they were just basically a mechanism for getting feathers into the country, because after importation, the feathers were taken off the dusters and were dyed, cleaned, and bleached, and then used to produce other items. It says in the case, or in the ruling, feather boas and hats. So this was at the time of importation. It was clear that these were not going to be sold as feather dusters, and customs reclassified them as feathers, basically treating the duster handle and the rest of it as packaging, I guess. But ignoring it and saying that they were not entered into the stream of commerce in their condition as imported. And as far as customs was concerned, that's what made this an artifice, right? So this is an inappropriate exercise in tariff engineering. And I don't know why, but I feel like this is what we're talking about, but who knows? Actually, I'm not sure what the source of these pictures are, but this is the beauty of the internet. You can find things. So that takes us to 1999 and 2001, and a very long-running case, again involving sugar, and many of the same issues that were discussed in Merritt versus Welch in 1888. So it's 111 years later, and a company in Canada refines sugar and makes sugar syrups for importation into the United States. And there, as I'm sure most everybody on this webinar knows, there are sugar quotas that are applicable to some formulations and not to others, depending on, in this case, the amount of non-sugar solid, excluding foreign substances. If it exceeds 6%, there's no quota, which obviously is a favorable classification, as opposed to the having less sugar solids in it, which means it is more highly refined. So this is very, the classification scheme is very analogous to the Dutch sugar color system from 1888. What Heartland did was apply for a ruling to customs, and they were clear what their process was, and that they were refining sugar syrup and then adding molasses back to the syrup for exportation to the United States, and then removing that added material after importation. We don't know in Merritt versus Welch whether that happened. I mean, I don't know, but I'm not sure that there's an easy way to do that, or was in 1888. But I also don't know a lot about sugar refining. But what I do know is that Heartland went to customs for a ruling, and customs ruled initially that molasses, which is derived from the sugar refining process, is not a foreign substance. So adding it in was counted toward the 6% sugar solid level, and that they were able to manufacture this product in a way to get to a 1702 9040 classification and avoid quota. So a couple smart things here. One, smart that the company figured that this was a means by which to engineer the product. Also smart that they got a ruling from customs, because this is a good time to point out if there is a substantial difference in the treatment of the product, whether it is tariffs or quota or admissibility or any other agency requirement, it makes sense to get a ruling from customs so that you have some level of predictability as to what's going to happen. Not always the case. That is something you should work out with your internal compliance team, or I would say honestly with your in-house counsel who's familiar with customs matters or outside counsel. Because if you unsuccessfully tariff engineer a product, then, as everybody on this call I'm sure knows, you have up to 5 years of liability as that goes on. So what you don't want to find out in the 6th year is that you've been improperly avoiding quota or improperly avoiding duty and have a large liability to deal with.
So Larry, if I could just interrupt for a minute. For those of you that may be trying to ask questions via the chat box, you should see a series of icons up on the upper right-hand corner of the screen. If you click on the arrow that says Show Control Panel, that should expand so that the chat box appears. So if you've been trying to ask a question, give that a try, and we'll see how that works.
Cool, thanks. Yeah, it's a little orange arrow will expand, and then click the arrow that says chat, and that'll open the chat box. Also, I'm going to apologize if you guys are hearing buzzing, because they've just decided to do some construction in the office here. So hopefully the audio is still good. Unfortunately, I can't do anything about that. All right, so rulings, important. Predictability, reasonable care, avoidance of substantial liability later on. So this was Heartland. Heartland started importing based upon the ruling that it got. And then, so this is the background that I just walked through, so we can go past that. Subsequently, based on what's called an interested party petition, the domestic industry went back to customs and asked them to reconsider the ruling. And customs did. And customs said that there was no commercial identity or use for the syrup as imported. In other words, it was a temporary product that was not going to enter the stream of commerce in the way it was imported with the extra molasses. So they revoked the ruling, and this set off a substantial chain of litigation and bad circumstances for Heartland byproducts. They owed a lot of money, and this was a substantial part of their business model, apparently. And they had done everything right. So remember, they had a ruling. So they're not going to be subject to penalties, but to the extent that they owed out of quota duties, there was a lot of money that they owed, right? So remember, reasonable care only gets you past duties if you can show reasonable care. Sorry, only gets you past penalties. But customs was always empowered to collect the right amount of duties. So there was a lot there. There's arguments about finality of liquidation and whether there was a violation. In this particular case, there was a lot of discussion after the fact about whether the importer had fully described the transaction. Right, this was part of customs' effort to collect. They said that the ruling request wasn't 100% clear or honest about what was happening. So all of those things need to be taken into consideration if you're going to do this and if you're going to try and get a ruling. So this went to the Court of International Trade, and the CIT reversed customs, said that Heartland had engaged in acceptable tariff engineering, that combining the sugar with the molasses before importation was a legitimate step in the refining process, and that it was not artifice. So merchandise had been properly invoiced, had been made accessible to customs for inspection, was properly described on the entries. So this question about what's a legitimate step in the refining process, if you think about that, this is not a step in the refining process. It's a backward step in the refining process. You're making the product have more molasses in it than it did when it was completed. But what's built into the court's reasoning here is Merritt versus Welch and Citron and other similar cases. And what the court is saying is that because importers have the right to structure their products in a way to receive a lower rate of duty, and that this company is in the business of refining sugar syrups, that is a legitimate step in their refining process, right? It's part of their business management of duty liability, and that is what those two earlier cases and multiple other cases state is the law. So that's the Court of International Trade said. We were all happy. Those of us who work with you guys as importers or brokers said this is a reaffirmation of the existing law, and thought that was the right way to go. So the Court of Appeals for the Federal Circuit, on the other hand, had a different view. The first was that there was a ruling. There's actually a Supreme Court case almost immediately before this decision from the Federal Circuit. It's an unrelated case. It's called Meade, M-E-A-D-E, and it involved a classification case, and the issue had to do with how much the Court of International Trade has to give weight to or give deference to customs, right? As a basic principle of administrative law, reviewing courts give deference to the agency that is charged with enforcing the law and interpreting the law, because those agencies are supposed to have expertise, unique expertise with respect to that substantive area of whether it's the environment or labor law or whatever it is. The agency involved is supposed to understand its own laws and regulations. The Court of International Trade and Customs is different because since almost the beginning of the country, these cases have always been reviewed what we call de novo, meaning the court does not really give much deference to the agency. And prior to 2000 or so, we would have said they gave no deference to the agency. However, in this Meade case, the Court of Appeals for the Supreme Court said, well, you don't give a lot of deference, but you give deference to the extent that the agency's interpretation is persuasive. So basically, it means that if the agency's position is logical and consistent and persuasive enough, that the court might find that despite disagreement with the result, that it is something that should be upheld. So that's background to what happened here. So first thing was the CIT did not give deference to the interpretation of what is a foreign substance. So in the revocation, the customs said, well, the molasses that goes back in is no longer naturally occurring in the syrup, right? Because it's been removed. So once it's been removed, it becomes a foreign substance. And the Court of International Trade didn't really pay attention to that. But what the Court of Appeals said was, we, meaning the Court of Appeals, have to give deference to that determination. And since customs said it's a foreign substance, then the exclusion from quota doesn't apply, which means this is no longer a tariff engineering question. It is a question about interpretation of the tariff, of classification. So keep that, put a pin in that thought, and we're going to come back to that very soon. How are we doing? I am really speaking quickly, and hopefully you guys are getting all this. So let's see. So what the conclusion was in favor of customs revocation. So there's an important concurring opinion, which goes to what we're talking about here. And it's a lot of text, but I'll just read it to you. And that is, since the addition and removal of the molasses from the sugar served no manufacturing or commercial purpose, The conclusion is irresistible that the only purpose for the strange arrangement was to create a fictitious product that, because of the temporary presence of the molasses, qualified for a lower rate of duty on sugar imports containing specified amounts of non-sugar solids. Right, so that is a concurring opinion from a Court of Appeals judge who is extremely suspicious of this notion of tariff engineering with temporary products. So what he, and I believe the judge was a he in this case, is concerned about is the fact that the product was not a product that was going to enter the stream of commerce in its imported condition. It was a temporary or fictional product designed entirely for purposes of establishing tariff classification at the time of entry. So he would have decided the case on the basis of tariff engineering and said that this was an artifice or disguise or similar language there too. But if we go back to the Pearl case, remember that the pearls came in a temporary condition. It was clear that they were going to be restrung and turned back into a necklace. So, and that what was actually entering the stream of commerce was not a group of unstrung and sorted pearls, but the guy had purchased and imported a pearl. I mean, a necklace, right? And yet, in that case, the Supreme Court did not focus on the post-importation use. Okay, so but this judge would have done that, which takes us to shoes. So this is your basic layout of a gym shoe, a sneaker, a running shoe, whatever the appropriate regional term is where you are. And I'm sure many of you know that there are pretty high duties on shoes, and some of the separating issues for high duties and low duties are the outer sole, the bottom sole. And there's been a number of disputes around trying to manage the tariff classification of shoes by engineering the soles. So the outer sole is the exposed part of the sole that contacts the ground. Footwear with a plastic sole or a rubber sole has a higher duty than soles made with textiles, right? So if you are working in really any industry, you can see what people in this industry did, which was they simply looked at the various headings that are applicable and what divides products in terms of tariff classification, and landed on the fact that the sole is the item that is most easily adjusted that would change the tariff classification. So importers or manufacturers engineered shoes to contain enough textile material in the outer sole, they hoped, that was their intention, to avoid the higher rates of duty, right? So now if you guys are contemplating something like this, or we are working with someone who's contemplating something like this, whether it's shoes or any other products, based on the customs ruling on feathers, and based upon the dissenting opinion, which is not controlling, but the dissenting opinion in Heartland byproducts, a thing to think about is how you're going to engineer that shoe sole to not be an artifice or disguise, to make sure that it is not a temporary or fictional product. So these are obviously slippers, and obviously would have a textile bottom, so lower rate of duty. So this ruling in 1994 is a good example of the way not to do this. So the importer made shoes with a plastic outer sole and glued some felt on the sole of these wooden clogs. It's not clear exactly how strong the glue was, how permanent it was, but we know that if you look at the second to the bottom point, and it just if you're following along here, so the little mask there, that's your artifice or disguise. That's your disguise. The magnifying glasses are how we do the analysis. But the felt was easily removed, and also it reduced traction, right? So it made the shoes more difficult to wear, or potentially more dangerous to wear, easily wore off with normal use in a short time. So we've got these clogs. They have probably have a plastic or a rubber sole on them in the ordinary course, but they have glued on them wool felt, and then they're entered as products with a textile sole. So according to customs, that shoe was not a commercial reality. Again, it is a fictional or temporary product, and therefore customs ruling is that this is not acceptable engineering, tariff engineering. So this is the position that customs has taken through to today, right? One way that customs believes a product to be improper tariff engineering is that the product is not sold in the condition in which it's imported. Even it's classified, normally classification is in the condition as imported, but what customs has focused on is whether the product is a real product. It is the product that people are purchasing. So if the felt on the bottom of this shoe was designed to come off or did easily come off, if it could be peeled off, then the idea is, the conclusion that customs has is that that's not really the product that's being imported. That is an artifice, that is a disguise. Okay, so this is a different ruling. This is a different ruling. We're still talking about shoes here, but this is more of customs analysis of tariff classification, and that is the key phrase here is, if customs finds that the article at the time of importation is a commercial reality, then the tariff engineering will not be considered a fraud or artifice, right? So commercial reality as opposed to a fictional or temporary product. This is what people are selling in the stream of commerce in the United States. This is what people expect the product to be. It is not simply covered up in a way or modified in a way to temporarily get it into the country. Now remember, and this is important, this is customs talking. This is not the court. And again, we have the Pearl case, and we have Welsh, and we have other cases coming up. But customs position is well encapsulated by this ruling. So what they said, sort of recapping here, in this ruling, 965752, is there was no apparent deceit. So just to be clear, this is also a textile shoe sole case. It had to do with slippers, and there was a question as to the actual nature of the sole. What customs said here is there was no apparent deceit as to the nature of these slippers. They were imported and sold with textile materials that remained intact. Even if the textile wore off quickly, again, we're talking about slippers here, the consumer did in fact wear it with the textile embedded in the sole, and that's how it was introduced into the stream of commerce. So there's a bit of a caveat here to what I said earlier. Here, customs is recognizing the material might wear off, but they're saying that is how it reached the stream of commerce, and people would wear it that way. So they said in this case, it was a legitimate exercise in tariff engineering, hence it's a commercial reality, and check mark at the end. Okay, so how are we determining what is a disguise or artifice? So there's a couple of places where I'm going to say, if you need to print a slide and remember it forever, I mean, you should have the materials, but this is a key summary here. So to benefit from tariff engineering, and again, this is custom speaking, The item must be a commercial reality, have a commercial identity, and be used in its condition as imported, right? So it is the thing you are planning to sell. It has to be a finished product, traded or used in its condition as imported. I know there's an or there, but those are basically the same idea. It is the product you're planning to sell and that the purchaser is planning to buy. The product must be part of a genuine step in the manufacturing process. That harkens back to Heartland byproducts and whether the addition of molasses back into the sugar stream or the sugar syrup was a genuine step in the refining process. So, but here they're talking more about, is there a manufacturing reason for this other than the assignment of a lower rate of duty? So this one I think is a shaky proposition for customs. That said, this is part of their analysis. So if the added feature that allows the importer to obtain a lower rate of duty is removed shortly after importation, that is an artifice. And I would also say it's a disguise. If you're disguising a rubber sole or plastic soled shoe by putting a piece of felt over it, then you're disguising the nature of the shoe, or you're engaged in artifice, which is a dishonest effort to hide the truth. Okay, so these are sort of the touch points you should be thinking about when you're talking to product development and purchasing people about products. Right, so that's your, I don't know, it's a mask. So just some examples here. So I will say, just to be clear, the tariff changes, the explanatory notes change. So I'm not 100% certain now that this would work, but this is what Converse did. The fine folks at Nike, which I believe owns Converse, engineered a sole that is partially rubber and partially textile material. I'm sure that the engineers were very clear on what the surface area is of that sole and the surface area that is textile versus rubber, and also to the performance for the actual shoe. This is the way they make Chuck Taylor soles. I don't know if anybody out there is wearing a pair and can confirm that they still look like this, but this was a thing. And so just applying the analysis that customs did to this product, we find that this is a real product. It's going to be sold to consumers in exactly this way. My understanding is that the felt or textile material was not temporary. This would not peel off. I don't know what's under there, but it was not intended to be a temporary product. It was exactly what was going to reach the consumers. So there is not a ruling that I found on this particular configuration of products, but this seems to take into consideration exactly what is in the customs rulings, and therefore results in a what I would say is a successful exercise in tariff engineering. Now, we get into multiple issues about classification, right? So there is a question about whether that sole is rubber or textile, and there may be an issue as to whether it is whether essential character is what controls the tariff classification, or whether I don't know, it's some sort of a composite, which would still result in an essential character analysis. So the product still has to be classified properly. And again, you're going to put a mental pin in that, because we're going to come back to that momentarily. So just because of the nature of the way we're doing this today, obviously we've gone through a lot of slides so far, and I've been doing this quickly because it's hard to, there's not a lot of interaction, which I understand. But what I'm leading up to is, unless Brian tells me otherwise from the other room, I think it's a good time to take a break just based on what's about to come up. And I would suggest we take a 10-minute break and we reconvene at 10 o'clock Central Time. So it's 9:50 now by my clock. We'll come back at 10 and we'll do the back part of this. So hang on, everybody. And Brian's here now. You're okay with that? All right. So we'll do that. Let's take a 10-minute break. I'm going to go on mute. Please make an effort to find your chat box and let me know if you've got questions. Thanks. Okay, I am back. Hopefully you all are back as well. I suspect the majority of you are doing this from home. So I am curious how many of your family has walked by and said, why are you staring at a picture of Chuck Taylor's? Which when you are a customs and trade person, you get to say, oh, interesting story. Let me tell you why the sole of the shoe looks like that, which is kind of what we're going to do for the next couple of slides. We'll talk about different products. So this is a football jersey made by Nike. So those of you who know me, I'm not really a football guy. But I am told that this is a new style of product. And what this is a jersey that goes under, obviously under the pads. And there's an outer jersey that goes over that. And but this jersey has these, I think they're neoprene or they're foam padding, which is permanently attached to the to a jersey. And the question is, who decided that this is a product that needs to exist? It didn't exist for years. Now, obviously, there is technology that changes, and maybe there's another reason for this, but I suspect not. And the answer, at least in theory, this is my theory, because again, I'm not speaking for Nike or Riddle or anybody else that makes these things, has to do with this and then a court case we'll talk about. So sweaters, pullovers, sweatshirts, etc., knitted or crocheted, would end up being classified in a provision that has a 32% rate of duty. That is an extraordinarily high rate of duty. Most of you deal in duties that are 5% or under. On the other hand, sports equipment, articles and equipment for general physical exercise, gymnastics, or athletics, parts and accessories thereof, is 4.6%. So you can see from that Nike has an incentive to make a jersey which is in fact classifiable as sports equipment, right? There's a 28% difference in duty. So there were some court cases around this issue, not with respect to football jerseys, but with respect to hockey pants and hockey items. At the time, the name of the case, it's Nike Bauer. Bauer is a hockey company. I don't think Nike is still in that business, but I don't know for certain. Nevertheless, in this Nike Bauer case, there was a question about hockey pants and whether they were classifiable as sports equipment or as pants. And what the court came down to was that, well, so just for background, the pants had pockets in them, not pockets for holding your keys in your wallet, but slots, I'll call them, where pads could be inserted into the pants, and then for protection while playing hockey. And then but they were not permanent. And then apparently the pants were similar enough to regular shorts or pants. I'm not sure exactly what they look like, that they could be worn in out and about, or might be worn out or about without the pads. So we get to this question about, and they were sold and imported with the pads, but you get to this question about, well, the shorts themselves, the pants themselves, are those classifiable as shorts or pants, or were they sports equipment? And the answer came down to the permanence of the padding and whether they would be used for other purposes, and whether there was anything that sort of dedicated them. So those of you who do classification, dedicated them to Chapter 95 for sports equipment. There were some rulings then on football jerseys, which had similar construction, which allowed for slots for under pad pads, right? Which is what these are. And again, the custom said no. Custom said no, that's not sports equipment. So I think the way I envision the meeting at Riddle, which I think was the first company to do this, but I don't know for certain. If any of you know, let us know. I think the first thing was, well, we can fix that. And we can fix that by actually gluing the pads onto the shirt and then importing the shirt. So the manufacturing process, if you could go back to my Mushu pork analogy, right? It's not a problem from a manufacturing standpoint. We can sell the product. There's no other reasons not to do this. And if it costs less than 28%, then there's still going to be a savings, right? Because remember, that's the duty difference. So there was that, a meeting apparently occurred, and some manufacturing people decided that it was possible to do. And next thing you know, these are out in the marketplace, and that is, I believe, fully because of Tariff engineering. Here's another example. So 32 versus 4.6. Everybody gets that. All right, here's another example. This is a RCA television, and sticking out of the side is a DVD because it is a combination DVD DVD player television. So it's built in. Now, a few years back, that may have been a more popular product. We'll talk about what's going on today with this issue, but it's a question of whether anybody really wants that product. There's a level of convenience. People will buy it, but particularly today, where more media is streaming than on DVDs, I don't know how common this product is. But what's the thinking behind it? Well, it's at least in part this. So we're talking about flat panel televisions incorporating a video recording or reproducing apparatus. So that video reproducing apparatus is the DVD player, and that is a 3.9% rate of duty. So the other, meaning not incorporating a video recording or reproducing apparatus, is 5%. So there's a 1.1% duty difference there, which, depending on your volumes and your values, could be a significant enough reason. And if it only costs 1% or less to add a DVD player, which seems unlikely, but we don't know what buying in volume or what the engineering of these things is. That's a duty savings that is worth looking at. So now we'll get to that. I don't want to jump ahead. Going back to this, if you were to look at rulings on this issue now, all right, those of you who have even relatively modern televisions will note that on the sides or backs or someplace on your television, there's usually a USB connector, right? So the USB connector is not for video, basic video input. It is not your HDMI connector to your cable box. It's not one of your other means of connecting to a video signal. So what's that for? Well, most modern TVs have the ability, if you plug in a USB stick, to play, to display still images or play short videos from the DVD. I'm sorry, not from the DVD, but from the USB stick. So that, from a classification standpoint, fills the requirement of being able to reproduce or record, although in this case, we're talking about reproducing video. And I can tell you with some degree of certainty that it is much cheaper to put a USB plug and the appropriate software onto the television than it is to build in an actual DVD player. So, I would query those of you who are listening, and I'm sure it happens, but how much that ability has affected your choice in a television, And how many of you have ever actually used the ability to plug a USB stick into your TV? I mean, I've done it, but it is certainly not an important feature. But it does save 1% on the duty, and that is a worthwhile thing, again, if it's less than 1% in cost to do it. Okay. If anybody else has examples of products that they suspect are tariff engineered, let me know. And let's see. I got one person here who said that they're not hearing us. Can somebody just confirm that we got audio now? Send a note here. Oh, okay. Thank you, Anne. Thanks, everybody who responded. Anne, I'm glad you're back. So, okay, we can go. So that's the television. All right, so the big update is what's going on with this, the Ford Transit. And then we'll get back to, after this, we're gonna do a short part on anti-dumping countervailing duties, and then we'll wrap up. So the Ford Transit Connect is, as I think I mentioned, the poster child today for tariff engineering, and it is the subject of a considerable amount of controversy. So these are the two versions of the vehicle. I know many of you have heard me talk about this, but there's activity, so we're gonna do the background. They all came into the country the way they are on the left side of your screen, which means that they've got a rear window, and where that rear window is, there is a rear seat. The rear seat has seat belts. It has an overhead light. There is what they call a footwell, an indentation in front of the seat, the rear seat, that allows passengers to put their feet in a more comfortable position. It is entirely 100% road legal, could be sold in that condition. However, Ford didn't sell them in that condition. For 100% of one configuration of these, after importation, they were converted into the vehicle on the right, which you can see that the rear windows have been replaced. And if you were to open that rear sliding door, what you would see is that the rear seat has been removed, the seat belts have been removed, and the footwell has actually been filled with a metal structure that creates a flat cargo floor, and you end up with a cargo van. Now, why would Ford go to all this trouble? Ford goes to all this trouble because of what's called the chicken tax, which has been on the books since the 1960s, when the U.S. had a dispute about poultry exports to the European Union, and retaliated with a 25% duty on vehicles principally designed for, vehicles for the transport of goods, 25%, as opposed to 2.5% for vehicles principally designed for the transport of passengers. So bringing in a passenger van at 2.5%, the question is, can it be converted? The question that Ford asked internally is, can we convert that vehicle to a passenger van for less than 25% of the value of the vehicle? And if so, there's an economic reason to do this, and that is exactly what they did. I think I just covered most of this background. The chicken is the chicken tax. The vehicle's imported with 4 doors, rear bench seat, rear side windows, passenger van. Just to be clear, Ford imported a different model, a different configuration with a rear seat and a rear, well, basically just the rear seat that was a much higher quality. And that higher quality rear seat was in fact sold through to the public, to the buying public. So that was a different configuration of the vehicle. The vehicle at issue in the court case had a rear seat, which, although entirely legal and entirely functional as a seat, was not something that Ford actually did offer for sale. Okay, so keep that in mind as we go through this. So I think I covered this. Swing out doors, swing out front doors, sliding door behind, second row windows, rear doors, not the rear passenger door, but the cargo doors were swing out doors. Second row bench seat. The thing about it's not being as good of a seat, in a typical car bench seat, they have these stiff wires which provide support to the person. So it's not just stuffed, like a stuffed comfy chair. But they didn't have all of those comfort wires in this the seat that they used. It was an inexpensive, more expensive fabric. But it did have child locks, carpeted rear footwells, dome lights, and a cloth headliner, all of which are things you would not typically find in a cargo vehicle. So that's the as imported configuration. So in the conversion process, this was done actually after customs clearance, but still within the confines of the port. They were taken over to what's called an upfitting company to do the conversion. The rear seats were removed, the rear safety belts and restraints were removed, the rear footwell was covered, a cargo mat was added to the back, scuff plates were added to the second row door sills. Scuff plates are what's used to protect the vehicle and also heavy, whatever products are being moved in when they're sort of slid up the door sill. And then the option of the customer ordering the vehicle, they could remove the side window, as you saw in that first picture, and replace it with an opaque metal plate that fit in and looked like the sidewall of the vehicle. So all of that was done while still in the port, but after clearance. So at this point, if we were all in the same room, I would say, okay, let's discuss that and what do we think? If anybody's got a thought on it, but the question, if you think about the analysis that customs employed in the prior rulings, it's clear that this is a temporary product, right? As imported, this configuration of the Transit was not intended to be sold to end customers. Some people have said that it is relevant and important to note that the rear seat, after it was removed, was not reused. So these seats were not recycled or well, I think they were actually physically recycled into materials, but they weren't used in any vehicle that hit the road. I'm not sure that fact matters, but people have pointed it out in a lot of these discussions. No doubt this is a bold move, right? What Ford was doing, and they did not, as I had talked about earlier, did not get a ruling. It is clear that customs was aware of this for a while. There was, in fact, a Wall Street Journal article about this process and how the Ford was avoiding the chicken tax by doing this upfit process in the port of Baltimore, I think, Baltimore. So it was known. Then at some point subsequent to the article, customs came into the facility and issued notices to Ford. I'm not sure, I'm not involved in this, just to be 100% clear. I am not directly involved in this issue at this stage of things. The customs either rate advanced them or took some other action, and Ford protested. Customs denied the protest, which allowed the parties to go, or Ford, to file a summons at the Court of International Trade challenging the rate advance to the 25%. So you guys can think about this. I don't know the numbers. If you just think about, you know, these vehicles, I don't know, entered value, $18,000, $25,000. Who knows how many of them were imported? This is a big deal issue for everybody involved. So the Court of International Trade decided this, I don't have the date on here, a while back, but here's the, this is the top end of the decision. There is a confidential version because there's some cost information and some production process information in it. But Judge Barnett of the Court of International Trade, in a long and detailed decision, which you can find on the CIT's website, which is cit.uscourts.gov, in 2017 issued this decision and found that the vehicles were properly classified under 870323 as motor cars and other motor vehicles principally designed for the transport of persons. So that's a win for Ford, right? What the court's analysis focused on was condition as imported. And, you know, to be fairly blunt about it, what the court said was, these are passenger cars with crappy back seats, right? The fact that they were going to be removed and that they were going to be, the vehicles would be converted is not problematic because the vehicle was properly presented to Customs for review. Customs actually was aware of it, but could have looked at them at any given time, and they were properly described on the invoicing as and the 7501. There was no disguise or artifice. There was no attempt to hide what the vehicle was in its condition as imported. So yeah, it is not a comfortable rear seat, but it still has the physical characteristics of a passenger vehicle rather than a vehicle for the transport of goods. And the court looked back at a case called Morabeni, which was from the early days of sport utility vehicles. And the question there was whether the Nissan Pathfinder was a car or a truck for the same reason. And the court said, well, look at these various characteristics: the presence of a rear seat, the lack of a divider between the rear seat and the driver. You know, cargo vehicles tend to have a divider there. Carpeting, footwells, all of those things, which the engineering folks at Ford had taken into consideration when designing the Transit that would be converted. So they followed the Morabeni analysis carefully, and Judge Barnett applied that analysis and said that the vehicle as imported is classifiable as a passenger vehicle. So whenever you're talking about a case that has this amount of money involved and as important a principle as this, certainly going to end up with an appeal regardless of who wins. Oops, I am stuck. There we go. This is what I just told you. Classification occurs at the time of entry, not post-entry. The court did not allow the focus on post-entry processing, and said that post-importation, take a step back. What the court said was that if it allowed Customs to focus on post-importation processing, it would impair the swift entry process for Customs, right? If every time something was imported through the clearance process, Customs had the ability to stop and ask, well, what are you going to do with this after importation, right? And we're not talking about a classification based upon use, although we're going to come back to that. Then it just creates a potential bottleneck. So the court, Judge Barnett again, focused on condition as imported, and held in favor of Ford. Structural and auxiliary features are what mattered. Intended purpose is determined from an examination of the structural and auxiliary design features. Again, this is the footwells, the seat belts, the fact of the seats. Then the court held, when, as here, the relevant intent is to avoid higher duties, the court is bound to follow the Supreme Court view that such intent is immaterial to an article's classification. Okay, this is, in my view, 100% in line with the pearl necklace, right? Shouldn't matter what's going to happen to it afterwards. You're looking at the condition in which it's imported, and that makes a clear line and allows the importer to know what customs is facing when it classifies the merchandise, and allows customs, or prohibits customs, from having a sort of searching review of potential post-importation intent and use. Again, we'll come back to use. So that made Ford very happy and made the government very unhappy. So, but there's a hidden problem in this case that's about to rear its head. And this is new material. This was not the case when I last did this program for the ITCC. So the classification for vehicles for the transport of persons, the actual heading reads as what's on the screen here: motor cars and other motor vehicles principally designed for the transport of persons, including station wagons and racing cars. So what we're going to end up focused on here is, what does principally designed mean? Okay, so keep that in mind, right? So this went up to the Court of Appeals for the Federal Circuit, and you need to know a little bit of background. And there was a series of cases, starting with a case called Camelback. So those of you who run or hike or are cyclists are probably familiar with these products. They're basically backpacks that also have a bladder in them in which either water or a drink can be held. And then there's a tube that comes around and you drink from the backpack. And there was a question about whether those products were classifiable as backpacks or as conveyances for food and beverages. And the real question came down to whether it was a use provision. Is a backpack a use provision, or a container conveyance for food or beverage a use provision, or whether it was an eo nomine provision, meaning it's just the name of a product. It's a backpack, name a thing. And the court said, well, you can do both. You can name a thing, and the name of the thing can suggest a use. And when that is true, then evidence of post-importation use should not be ignored, right? So that was Camelback, and it's a ways back, but it did cause a bit of a kerfuffle, if that's the legal term, in court, and there was a strong dissent. And people, I think, sort of thought of it as a one-off decision. Subsequent to that, there was a case called GRK Canada. And again, this is Court of Appeals. And in GRK Canada, the issue was the classification of wood screws, right? So there is a tariff classification for wood screws, and there are classifications for screws based upon physical characteristics, whether they're self-tapping screws, the size and shape of the head, the size and shape of the threads. There's a bunch of physical characteristics that go into classifying bolts and screws. And there is a well understood and defined set of characteristics that describe what would commercially be sold as a wood screw. And in GRK, the Court of International Trade did not consider the post-entry use of the screws, how they were actually used or intended to be used or marketed for use. It looked at the physical characteristics that define a wood screw and the physical characteristics that define all other kinds of screws. And Customs said that that's not right. The argument from the court was, well, look at Camelback, and the issue is, does the term wood screw suggest a use of the product, a post-importation use? And if it does, then that is not then evidence of use in a way that is inconsistent with that. So meaning use other than in wood would be relevant and should be considered. So it was sent back down to the Court of International Trade. It went back up again, again over a strong dissent in that case about the traditional difference between AO nominee classifications that describe products by use and those headings which are identifiable as use provisions or actual use provisions, and the rules around whether something is principally used, goods of that class or kind, principally used, or actual use, which has its own regulatory requirements, as you all know, for certifications within, I think it's 3 years of importation, proof of actual use, and how traditionally those classification methods have been separated. But this notion of an AO nominee classification that suggests a use is something that the Court of Appeals for the Federal Circuit has moved toward over the course of the last decade, from Camelback and GRK to today. As you might imagine from my long lead up to this, this is a problem for Ford. So according to the court, a vehicle that is principally designed for the transport of passengers will most often or typically be used for the transport of passengers. And that principally designed for the transport of passengers suggests a use consistent with the design. And because of that, following Camelback and GRK, the court looked at evidence of post-importation use, and for these vehicles, for the subset of the transit, 100% of the vehicles would eventually be used for the transport of cargoes, therefore reversed. This is the current status. So there was a motion for the Court of Appeals for the Federal Circuit to rehear the case en banc, which means with the entire 12 or 13 members of that court sitting together. Rehearing was denied. The case currently stands as decided, and that means that the court will, that the current law is that if you have an AO nominee classification that suggests a particular use, that the court will, which also translates into Customs may, look at evidence of use for that product in doing the classification at the time of importation, or more importantly for all of us, potentially at the time of an audit, which raises all kinds of questions about how do you do that post-entry? How would you determine, particularly if you're not the end user, what the consumers are actually doing with the product? And also, in what case does when exactly do we find an AO nominee provision that suggests a use? So there are not real good rules on this, and there is not a clear weight to be given there. the court here basically used evidence of use to completely overcome the physical characteristics of the vehicle. So in other words, they said, right, evidence of use as a cargo vehicle is enough to get past the fact that there is a fully street legal, fully functional rear seat belts, footwells, rear light, and all the rest of it that we talked about in the vehicle. So we don't also know what the weight to be given to subsequent use is, but it is very, at least based in this case, given quite a bit of weight. So things to remember, right? Think about everything that I just talked about with respect to the Court of Appeals for the Federal Circuit, and remember this. A case is no longer about tariff engineering, right? So there's been a lot of press written about this, about whether the Court of Appeals decision in Ford is the end of tariff engineering. What the Court of Appeals did was not focus on tariff engineering at all. It has just, in my mind, muddied up the tariff classification as between passenger vehicles and cargo vehicles by looking at subsequent use. But this is because the way they're interpreting the two headings, not because it does not in any way undercut the ability of a party to engineer its product. But it means if you do that, you have to be rock solid certain that you're properly classifying the vehicle or whatever the item is, not necessarily a vehicle, right? So this is all about the proper interpretation of the two competing headings. And then this new notion of a AO nominee provision suggesting a use, which again is not in and of itself addressed to whether there was a disguise or artifice, right? That whole discussion about the transit classification was not about disguise or artifice. So again, this case so far is about how to read the tariff schedule, which is a turn from where everybody thought it was going. So just trying to think about how to apply this going forward. So does this heading suggest a use? Motor cars, motor vehicles principally designed for the transport of persons, including station wagons and racing cars. I don't know the answer to this. I think that principally designed this is my own personal view, is an indication that you should be looking at design characteristics and not use. In fact, I think there is an argument to be made that the primary focus that the engineers at Ford probably had when designing this vehicle was to design a vehicle for the transport of persons, while at the same time ensuring that it was easily convertible into a cargo van, right? I think if, and I'm not involved in this at this point, so if there were evidence from engineers that what their job was to design a passenger car knowing that it was going to be converted, then what do you do? What does principally designed mean then, other than, yeah, that was our job. We designed it to be a passenger car. So, but that's not what won the day. So does this suggest a use? Does that even matter? Should suggest a use even be a question for tariff classification purposes? And all I can tell you right now is that it's going to be up to these guys to decide. So a few months back, Ford filed a petition for cert asking the Supreme Court to review the Federal Circuit's decision. I can tell you, because I hedged about this a couple times with my own level of involvement, yesterday, the Customs and International Trade Bar Association filed an amicus brief in support of Ford's petition, not so much saying that Ford did the right thing or even addressing the disguise or artifice issue, but arguing that this notion of a new category of tariff classification, which is a hybrid between a traditional use provision and an AO nominee provision, is wrong. It is inconsistent with the Pearl case, the Citroen case, and the notion that goods are classified in their condition as imported. So that brief was filed yesterday. I don't know if other parties have filed briefs in support or in opposition to the petition, but we'll see what happens. It's the brief that Ford wrote, or that Ford's counsel wrote, which I've read, is a good brief. So hopefully it'll catch the attention of somebody. It is always the statistical considerations are not in your favor anytime you're applying for Supreme Court review. So we'll see what happens. So let's do a couple things here. The first is to summarize, because these are your sort of takeaways. Right now, the law continues to be goods are classified in their condition as imported. Ford did nothing to upset that. It's just that the Ford issue was how you read the headings. The importers can configure their products to achieve a lower rate of duty. The Ford decision did nothing to undercut that, except that you got to make sure whatever you engineer into, you're properly interpreting. Still, the law is no artifice or disguise. Understand use and its impact on classification. That is this question about, is it possible that you've engineered into a provision, but that it's still not classified properly and you didn't successfully get there? And this is complicated by the Ford decision. And then I want to spend some time talking about anti-dumping and countervailing duties. And I'll come back to that. So how to avoid artifice or disguise, particularly if you are doing a ruling request, right? So truthful and complete descriptions to Customs. Customs hung its hat in Heartland Byproducts when it revoked that ruling on Heartland's alleged failure to fully describe the process. Make sure that the product you are creating has a commercial identity and is actually used in its imported condition. Now, if the Supreme Court takes up Ford and reaffirms the Pearl case, then this will be less of an issue because use will not be an issue. But currently, in terms of first line of contact with a ruling request or a CF-28 or whatever you're dealing with the agency on, if you're doing tariff engineering, you want to ensure that the product you're importing has a commercial identity. Avoid a temporary product, and the production process should have a commercial purpose other than duty avoidance. Again, if the Supreme Court takes this case up, that last bullet point might go away, but you should have an explanation if you were going to Customs on a ruling request or a response to a request for information. You should have an explanation for why the product is configured as it is. So questions to ask internally: can the product actually be made, right? If you design the product in a way for the best duty treatment, are you still gonna be able to sell it, right? Does anybody want a product engineered the way you're proposing? If nobody wants it, there's no point in this. If you don't think you can sell it, there's no point in this. What's the change going to cost? So what does it cost to put a USB port and the appropriate software on a TV? If it's less than 1%, have at it. It makes sense. But we're living in a world now where MFN tariffs are not the only thing we're worried about. So we have to spend a little bit of time talking about circumvention, which I don't have slides for, but we can talk through this, and then we'll wrap up. Anti-dumping countervailing duties are not controlled by the same rules in terms of tariff engineering, right? So there is a specific provision in the law that says that importers are not allowed to circumvent an order by taking a product and making minor alterations to it, or completing it in a third country in a way, country not subject to the anti-dumping duties in a way that does not require significant investment in machinery and equipment, time and labor. They look at a bunch of factors. So, and also there's a question of whether the new product was a product that existed prior to the date of the order. So if the product as configured after thinking about it from an engineering standpoint did not exist, so that the petitioners would not have known to include it in the petition, then there's a higher chance that making relatively small changes to the product will not get it out from under the scope of the order. And then again, if the changes, regardless to the product, do not require a significant investment in labor and time, there was not a lot of research and development done, the production in the third country is simpler than the production that would have been done in the country of original production, all of those things are an indication of circumvention, which is an entirely different standard and test than what's been applied, what we're talking about here for standard MFN duty situations, right? So the Department of Commerce, not Customs, makes the final determination in a circumvention case. So it is important, if what you are trying to avoid is anti-dumping duties, that you be aware that really everything that we talked about to this point is illustrative, but does not control this analysis. So you have to be careful. The stakes are much higher here, and there is specific law on this. Now, just for definitional purposes, keep in mind that circumvention is different than evasion. Evasion is a customs process, not a commerce process, or customs investigates allegations of evasion, most of which have related to transshipment, straight up avoiding, evading duties by transshipping and not making physical engineering changes to products. So that's a different thing, also bad. But circumvention is a Commerce Department issue, and it comes up through a Commerce Department circumvention inquiry, usually kicked off by Petitioners Council, and then there's a briefing process to go through that process. So you need to be careful about that, and I want to be sure you understand the distinction. So that said, that's all I've got in terms of materials. So I am happy to take questions if anybody's figured out. Well, several of you have answered my audio questions, so I know you know how to do it. So if there's questions, I am happy to take questions. We got about 10 minutes. And also, really, because I am enough of a nerd about this stuff that I'm interested in examples. If you guys have examples that you can share, things you've seen in the marketplace, I'm collecting them to add to my Chuck Taylors and my Nike shirts. So okay, so here's a question that came in. The question is, what about tariff engineering to change country of origin for duty purposes? 100% same analysis to undertake. However, in terms of can you do it, does it make sense, can you sell the product, and all of that. But the test is different. We're not talking about classification at that point. We're talking about either is there a substantial transformation, right? So is there a new product? Does a new product emerge with a new name, character, or use as a result of processing that is not simple or minor, right? So this is closer to, it's not the same, but it's closer to a circumvention analysis, but it definitely falls into the category of re-engineering products in order to establish a lower rate of duty. So you absolutely can do this. There have been, in the era of 232 and 301 duties, a number of what I consider to be surprising rulings, some of which I think are just completely wrong, where people have re-engineered their supply chain in order to try and modify the country of origin and avoid the 301 duties on products from China, and customs has, in some cases, made what I think are questionable or incorrect rulings. So you need to be careful about that. Remember, though, that the test, it is not about getting it in the right heading, which is everything we've talked about. It is about identifying a substantial transformation, name, character, use. Look at those rulings. I would commend those of you who are sitting at your computers can jump on Cross and look for a ruling that was issued to Volvo involving motor vehicle parts from China, subassemblies, large subassemblies, just to be fair, that were exported to Sweden and then assembled in Sweden to make motor vehicles. Read that. Answer is they're still parts. They're still China. It's still a Chinese vehicle. So then someone else has asked, well, what's the definition of simple assembly? It's simple assembly or minor combining. So substantial transformation comes out of court cases. So there is a definition of simple assembly, which is in the NAFTA marking rules. The NAFTA marking rules are only applicable to products of Canada and Mexico imported in the United States, and those rules do not apply to the question of whether products from Canada and Mexico are subject to the 301 duties, right? So you can have, as odd as it may seem, you can have a product that is NAFTA originating, marked a product of Mexico, duty-free for the standard column 1 rates of duty, but still subject to 301, right? So just to answer your question, the simple assembly rule, if I remember right, is combining 5 or more components by welding, force fitting, gluing, some other means. There's a bunch of means. That is good for, I would say, guidance, but it is not control. Basically, what customs looks at is how many parts come together, how complicated it is, how hard it is to do that assembly, what types of tools were involved, do the workers require training, what's the added value for country of origin, and those types of factors. One thing I will say that is increasingly important these days, because of so much of what we do is electronic and connected devices, customs is spending a lot of time thinking about software that's embedded into products. And we're not just talking about products that are computers or obviously include software, but also firmware, which is things that are just baked into electronic devices. Things like there's one court case involving flashlights that had a circuit board in them and some programming on them. So if the programming comes from a country other than where the parts are assembled, that can be helpful as well. There's a bunch of rulings on that. Another question or a point is, I have found that we can create different name, character, use, but still could be simple assembly and might not mitigate 301. That is 100% true. So name, character, use is modified by the fact that the name, character, use, the change in name, character, use must arrive by more than simple assembly or minor combining. So while name, character, use is the way the test is often stated, the rulings are clear, and the more recent court cases are clear that it's name, character, use, a change in name, character, use as a result of more than simple assembly and more than minor combining. So here's an example someone has. A toolkit consisting of 9 pieces, including a textile tool bag, not specifically shaped or fitted to the tools. So what I'm picturing are those things that look like old school doctor bags, but they're made out of like canvas. They open at the top, they're not fitted. So yes, person says yes. Okay, so they can be, let's see, 9-piece toolkit, including a bag, not specifically fitted, can they be packaged separately in the same container and in an equal number and be assembled into a kit after the goods are already arrived? Declare each item on its own value duty rate instead of as a kit under 8206. Okay, so I'm going to demur on this because that is a very specific question, and I'm a little concerned about not knowing the facts. But just as a general principle, you know, if things arrive together in the same conveyance on the same date in the same port, it is possible for them to be classified as an unassembled, disassembled item or as an entirety. So if I were looking at that, you know, I would ask myself whether those toolkits can be shipped separately to arrive on separate times and possibly in separate ports. Otherwise, you know, again, depending on the specifics of the case, you know, which to give an actual answer, we'd want to know more. But that would be, you know, something that would be a good opportunity for a ruling. I will say to the person who asked this, I am sure you're aware of this, but there are all kinds of complications in 8206 tool sets and how 301 is being applied. There's been a bunch of exclusions to avoid this double counting problem that had happened. So I know it's not a very specific answer, but it's a complicated question. Next question, it often seems the test CBP applies is change in name, character, and use, not change in name, character, or use. My thoughts are it's or, but my thoughts are not lined up with customs. So this is a problem with some loose language in court cases and rulings. So you can see it going back and forth. The original court case that set this rule out is this Anheuser-Busch case involving corks. And then the main case where we see this is Gibson-Thompson, which involved wooden hairbrush handles and toothbrush handles. And those cases talk about name, character, or use. And I would tell you that character means much more than name, and probably more than use. There are a number of rulings that say a change in name is the least indicative, and you should focus on character or use. And I think there's been some debate back and forth, but if you trace it back, it appears to be name, character, or use. However, what everybody on this this webinar is probably trying to accomplish in dealing with customs in real time, customs is going to ignore changes in name that do not include a change in character or use. So I think it is probably most accurate to say it is a change in name and either character or use is probably the best current way to assess that. I'm looking at Brian. You agree with that? Brian says he agrees. All right. Anything else? We are right on time for wrapping up. I hope that this was useful for everybody. I hope that it gave you some opportunities. Those of you who are in-house or work closely with importer clients who are manufacturing things, gives you some things to think about. You know, what I would do if I were looking to add value to an employer or a client who hasn't thought about these things is just open up the chapter where the product is classified, and particularly within a heading, just go down the heading and look for the lower rates of duties and say, well, what's the difference? If the difference between, you know, a high duty and a low duty is a relatively minor engineering change, raise it and become the customs compliance person who adds value to the process. You do that, you'll be a rock star. So we are pretty much set. Brian, you want to wrap up with anything?
Thank you for attending, everyone, and we'll be working on getting the announcements out for another webinar next month, and hope to touch base with you all then. Take care.
There's a question about recordings. Do we make recordings available? No? that was probably heard, so we should just say it out loud. So we didn't record this, so we don't typically make the recordings available. You should have received the materials. So you have those. Hopefully that is helpful to you. So with that, everybody have a good day. Stay safe, stay healthy, and we will all be in touch.
And have a good weekend.